Well, everyone, welcome to this afternoon's session of the Kansas Court of Appeals. We are thankful to counsel for your flexibility in pivoting to this means instead of meeting in person in Wichita. My name is Catherine Gardner, and I'm serving as the presiding judge today. And I'm happy to sit today with Judge Tom Malone and Judge Angie Coble. I believe your case is set for 15 minutes, and so I will I'll just go ahead and call the case of 126749 Bradley Pistotnik Appellee versus Brian D. Pistotnik, Brian Collignon, and Pistotnik Law Offices LLC Appellants. Appearances, please.
May it please the court, Brian Pistotnik appearing. I believe, Your Honor, that Brian Collignon and John Pistotnik are also planning on joining by Zoom. I don't know if they're in attendance yet.
Okay, well, I think that Chelsea can probably handle that for us. She's working our IT end of that. So, and thank you for the correct pronunciation of Brian's name. And for Appellee.
Good afternoon, Nathan Elliott on behalf of Appellee Bradley A. Pistotnik.
Very good. And now I see those others have joined you, Brian. So we will go ahead. An appellant, let me know if you would like any rebuttal time, and then you may proceed.
All right, and Your Honor, I'd like to break my argument into 10 and 5, if I may.
You may. Please proceed.
May it please the court. This action filed by plaintiff was one for specific performance, and of course, specific performance is an equitable remedy, and it's all having to do with a prior receivership. And of course, that also is based in equity. In this case, why there was an abuse of discretion by the trial court is she basically refused to consider equity. In the court's ruling of June 5, 2023, she specifically put in the very first sentence of the ruling, it is the finding of the court that its analysis is limited to the four corners of the document. During the trial of this case, the judge would not allow evidence pertaining to any equitable arguments. We had to proffer exhibits. We had to proffer information about the equitable arguments. And it's because of that abuse of discretion that the court's ruling should be reversed.
Well, counsel, isn't it generally true that if we're wanting to specifically perform a contract, we would not look to equity?
And Your Honor, we're not trying to perform a contract. We're trying to basically indicate that it's not equitable for our firm to be allowed to use the name that we've gone by since 1987. And it's completely based in equity. A little bit of history about myself. You know, I'm a practicing lawyer. I've been a practicing lawyer since 1987. This is my 37th year. For the majority of my career, I was at 2831 East Central, and prominently displayed in front of the office was a sign that I purchased, a sign that I put up that stated Pistotnik Law. Currently at our new location, there's a large sign in front of the office, Pistotnik Law. We've always been known as Pistotnik Law, unlike Brad's office, the plaintiff's office, he's abandoned the use of the Pistotnik name in his office. He goes by the Bow Attorneys now, and Pistotnik Law is no longer part of his name. Because this is an equitable case, I would like to talk a little bit about the equity of what's happened in the past. From my perspective, there was nothing equitable at all about plaintiff coming to the office while we were partners and removing his files, removing computer information, and he did that over the weekend at night, discreetly. There was no advance notice of him leaving. From my perspective, there's nothing equitable about Brad's conduct of planning to do this. He created new websites 4 years prior to his departure. Once he filed the lawsuit, he asked the court to stop our use of the website. Actually, he took the website without permission and prominently displayed on the website that he's moving and everybody needs to go to him in his new office. When Brad left, he used the same marks, the Pistotnik Law logo was in the His new ad, he used the bull. Our firm had used the bull together before he left. Nothing equitable about him basically taking all our employees, taking the marks. Basically, what he did was open a new office and stole the old office. From my perspective, there was nothing equitable about the court. And this is in the old case, basically telling us we had to shut down and we could no longer use our website. And that was before the receivership even started. From my perspective, there was nothing equitable about me being forced to be in a receivership. There was nothing equitable about me having to take half of everything I earned and paid it to the receiver. When the receivership started in January 2015, our legal fees were $20,000 a month from the receiver. And the interesting part of that was I was running the business. I was paying the bills. I was handling the cases. All the receiver was doing was overseeing what I was doing. He didn't step in and take the cases. He didn't step in and take assets. He didn't step in and pay the bills. Basically, we continued doing that on our own. At one point, the receiver's account got as high as $500,000. By the end of the receivership, there was nothing there. When there was an agreement to try to get the receivership done, I was trying to stop the bleeding. In July, we basically agreed. Let's do an agreement to close the receivership. Let's do an agreement to stop everything, and we worked out a deal to pay everything off, and hopefully get the receivership closed. And that was the contract that there was a transcript of, and that occurred on July 16, 2015. Now, as the court is aware, the Court of Appeals, in our prior case, when we appealed the failure of the trial court at that time to close the receivership, the Court of Appeals ruled basically the district court is not bound by the agreement of the parties to terminate a receivership, even if that is what the parties agreed. In the Court of Appeal prior decision, they noted KSA 176808. And that statute, of course, indicates the district court has discretion to continue the receivership as long as the court shall think necessary for the receiver to complete its work. And where that falls into our arguments is the contract that we agreed to in July of 2015 was impossible and it was illegal. There really
Mr. Pistotnik,
yes.
could you remind me what the term was in the contract as to they were to close the receivership as soon as possible, as soon as plausible? I don't recall the specific language.
Yeah, it was, the specific language was as soon as possible. And that was the number one term of the contract. We need to get this closed. We need to stop paying all these funds to the receiver. And then, of course, a lot of facts changed after that.
And you agreed also that the domain, Pistotnik Law, would no longer be used, right? That would be killed, I think, was the terminology used.
That was, yeah, the terminology was it was going to be killed. And we agreed that let's get this done. And we agreed not to use it. Brad agreed not to use it. You know, back in 2010, Brad also made bradpistotniklaw.com and pistotnik.com in his plans to take the business. And one of the parts of that agreement was he wouldn't use pistotnik.com either. But because the main portion of the contract was let's close the receivership, we believe the whole contract was invalid and void. Now,
but there was a severability clause in there, correct?
No, Your Honor, the contract I agreed to was a transcript written into the record in the courtroom. Now, there was a subsequent written contract that Brad's attorneys drafted that was circulated like 5-6 months later. That contract I did not agree to, and they put that in that written contract. And we even had a hearing about the fact that I didn't agree to the terms of the written contract, which were different than the verbal contract. But Judge Henderson ordered me to sign that contract, and I signed it, noting that I was signing it under duress and involuntarily at the order of the court. As far as additional inequities, in this case, the interesting thing from my perspective is when they filed this action, they asked the court to basically shelve pistotniclaw.com. They did not ask us to stop using email addresses. It was only after the trial of this case and in a subsequent motion that I filed that the judge said, well, you can't, not only can you not use pistotniclaw.com, but you can't use your email addresses. And from basically when emails were created, whenever, whatever date that was, my email has always been brianpistotnik@pistotniclaw.com. One of our equitable arguments is the fact that from 2015 to 2024, we continued using @pistotniclaw.com. And not just me, but the whole office, my office, that is. We had 7 or 8 email addresses ending in that. And after the trial of this case, the judge summarily said, well, that's all part of it. And that wasn't even something that the plaintiff had requested in the case. So we had to change all our email addresses, even though that was a something that the plaintiff didn't even request in this case.
So just to clarify though, so you have changed your email addresses now?
We have new email addresses. The old email addresses are still getting emails. We don't send anything out by those, but we still monitor those for things that come in. And it's amazing after this long of a time frame, we still get plenty of emails on those old addresses. Even though we've been sending out, please don't send anything to this email, but we've been telling everybody our new email address, but we still get it. And I get it from courts, I get it from insurance companies, I get it from everybody I deal with on the old email address. It's very hard to change an email address. And with equitable estoppel, one of our main arguments today is we have used not only the email addresses, but we have owned Pistotnik Law from 2015 to 2024. And there's nothing equitable at this time to make us stop using either our email addresses or to stop using the website itself. You know, the Bull attorneys, they have their own website. It's totally different than us. We are known as Pistotnik Law. They're known as the Bull attorneys. And the trial court should have at least allowed us, the trial court should have at least considered equitable arguments in this case. And that's all I have. Thank you.
Thank you, counsel. Appellee, you may proceed.
Thank you. This appeal arises from the judgment entered after a one-day bench trial in a very straightforward breach of contract lawsuit. The trial court's ruling is factually supported, legally sound, and should be affirmed. My client filed suit seeking specific performance of a clear and enforceable written contract of settlement that was entered into in connection with a prior lawsuit involving the dissolution of a law firm owned by Brian Pistotnik and Brad Pistotnik. One of the terms of the settlement contract was that the domain pistotniclaw.com would be permanently deactivated. That was a heavily contested issue in that lawsuit. The dispute was between whether the domain belonged to the former law firm, which was the affiliated attorneys of Pistotnik law offices, or whether it belonged to Brad Pistotnik individually. There was never a contention in that case or this case that the domain belonged to Brian Pistotnik or his new law firm. During the Super Bowl in 2022, the appellants ran a television commercial directing viewers to the pistotniclaw.com domain. My client saw that commercial in real time and was thus made aware that the appellants were breaching the settlement agreement. This lawsuit followed. Contrary to what I believe I just heard, this is an action based on a written contract. While Brian Pistotnik did not necessarily want to sign the written contract, he was ordered by Judge Henderson in the prior lawsuit to sign it. My client had filed a motion to enforce the settlement agreement, which included signing the written document. The court granted that motion and compelled Brian Pistotnik to sign the written settlement agreement. He did so on November 12th, 2015.
So let me ask you then, his statement today and his comment under his signature saying this was done because he was forced to do it and under duress, the judge told him to do it, so he was complying and doing it. Shall we just ignore that?
I believe you should, because his remedy would have been to seek an appeal from that order. The prior lawsuit was resolved on final judgment in 2020. And Brian Postotnik testified in his deposition in this case, at trial in this case, and at a hearing in the prior lawsuit, that he was well aware that if he wanted to contest the validity or enforceability of the settlement contract that he was compelled to sign, his recourse for doing so was through seeking an appeal of the final judgment entered by Judge Comer in 2020. He elected not to do so. He testified in this case that he elected not to do so because he was tired and worn out and just wanted to move on with his life. Having elected to move on with his life without seeking appellate review of an order with which he disagreed, he is now foreclosed from seeking to set aside that order or just disregard it wholly as he sees fit. An issue that I want to address before getting into the further merits of this case is our position is that the appellants have acquiesced in the judgment from which they are appealing, and this court therefore lacks jurisdiction to even consider this appeal at this time. One of the very few terms of the court's ruling that is at issue here, it's at volume 1, pages 68 and 69. It's a 2-page court's ruling entered by Judge Hernandez Mitchell on June 5th, 2023, was that the domain postotniclaw.com was to be dismantled and permanently inactivated. The parties would designate a third party to dismantle and inactivate the domain, and that my client, the plaintiff and appellee, Brad Postotnik, would be required to pay the yearly fees to maintain its inactive status. The reason the parties want to maintain the inactive status is so that nobody else can come in and purchase that domain name, and maybe it would be of use to other competitive advertising law firms. 5 days after filing their notice of appeal in this case, Brian Postotnik sent an email to my partner, Russell Hazelwood, from his Postotnik Law Offices LLC email address, stating that Brad's first bill was coming due, and he asked us to provide Brad's credit card information so that he could submit payment charged to Brad to maintain the inactive status of the domain. Brad was certainly not willing to provide his credit card information to the appellants, so we instead told Brian that we would hand deliver the payment to him, and we did so. We hand delivered the $22 payment as requested by Brian Postotnik to Brian Postotnik at his law office, and he voluntarily accepted the payment and signed a receipt, acknowledging that the payment was made, quote, as directed by the court's June 5th, 2023 court's ruling, end quote. So by demanding and then voluntarily accepting this benefit of the court's ruling, the appellants have waived their right to appeal. There are no applicable exceptions to the doctrine of acquiescence that would apply here. The issues raised in this appeal are not separable or severable from the judgment that they have already enforced against Brad. The appellants were not coerced or forced to accept the payment involuntarily. In fact, they reached out to us asking for that payment, and we merely complied with their request. And the appellants were not forced to accept it as a form of self-protection. If the appellants had wanted to maintain the inactive status without enforcing the court's ruling, all they would have had to do is make the $22 payment themselves, and they elected not to do that. So it would be improper to require my client to pay for the registration fees for a domain that would be used to advertise for a competitive law firm or to house the competitive law firm's email addresses. And thus, because the appellants have acquiesced in the judgment, this court is deprived of jurisdiction and the appeal should be dismissed. Regarding the arguments that we just heard and have read in the brief regarding impossibility or illegality of the settlement contract, those are all issues that either were raised in the prior lawsuit or could have been raised in the prior lawsuit. And by either allowing those issues to not be raised on appeal or deciding not to appeal them for whatever reason, they are now foreclosed from raising those issues as a defense to a contract that has already been determined by the Sedgwick County District Court in the prior lawsuit to be a valid and enforceable contract.
Is that based
Mr.
on,
Elliott,
I was just
I'm
going to
sorry.
clarify, your argument there is based on res judicata?
Yes. Yeah, the parties are the same. The issue, oh, I'm sorry.
Oh, but I was just going to say, but the parties aren't all the same, are they? I mean, Mr. Collington, and I'm sorry if I just pronounced your name wrong. But not all the parties were present in that prior lawsuit, right?
Mr. Collignon was not a party to the lawsuit, but he is a party to the settlement contract that was enforced in that lawsuit. His signature appears right next to Brian Postotnik, and Brian Postotnik, on behalf of their new law firm, on I believe it's volume, maybe I don't want to try to find it right now, but he is absolutely a party to the settlement contract. He was not a named defendant in that case, but he was a party to the contract. The issue regarding the domain was hotly contested in that case and was already resolved. And thus res judicata would prevent relitigating this matter yet again.
Are there any cases you can point us to that would tell us that that's enough, that he's the party to the contract, though he wasn't a party to the lawsuit?
Not off the top of my head, no, Your Honor. But I believe being compelled to sign a contract is at minimum acquiescing to the court's jurisdiction over him. Otherwise, he would have had no reason to sign it to begin with. And he did testify in this case. He received substantial consideration for being a party to that contract. He had made claims, you know, asserting rights to, I don't know, $6 million in compensation or something like that in that underlying lawsuit, because he wasn't a party, but he filed claims against the receiver in that case. And resolution of the global dispute between everybody involved in the prior law firm resulted in the settlement contract that has already been enforced and found to be valid in the underlying lawsuit. So having had a chance to litigate the enforceability or impossibility or illegality of that contract, and then choosing not to pursue an appeal regarding those issues, the parties cannot be heard to complain about them at this point. Further, as briefed in our brief of appellee, the contract is not illegal, and it is not unenforceable. The term regarding termination of the receivership did not say it was going to happen immediately. It said the receivership would be terminated as soon as practicable, which obviously.
But isn't the argument, though, since it's really not within the party's ability to control termination of a receivership, it's more in the court's ability, that was impossible, regardless of the time. It could never happen.
I don't think so. I think the parties, and we cited various examples in our brief where parties can agree to seek certain relief from courts, including, you know, not contesting attorney's fees, things along that nature, that you can't compel a court to agree with you, but you can agree that you aren't going to stop the court from closing the receivership or awarding the attorney's fees or whatever the term may have been that the court ultimately has discretion to rule on. And here, yeah, the receivership did not end up closing until 2020. And if the delay in terminating the receivership was grounds for setting aside the contract, the final judgment in that underlying case would have been the time to file an appeal saying that because this receivership was not closed on time, I am no longer bound by this contract. And that did not happen. Regarding the arguments of equitable estoppel, I disagree that the court refused to consider it. The Judge Hernandez Mitchell simply found that she did not find that it applied in this case. She listened to the evidence that was put on and decided that in her discretion, which is the standard of review for equitable estoppel, abuse of discretion, in her discretion, it was not applicable here. There was nothing inequitable that would cause estoppel to apply in a situation where there are statutes of limitations that would apply to the enforcement of a contract. That was never raised as a defense in this case because my client was well within his statute of limitations for demand compliance with this contract. So having filed within the applicable statute of limitations, there's no reason that estoppel would supersede the statutory statute of limitations.
So how do you respond to the argument that if Brad was concerned about the use of these email addresses, that he should have pointed that out as they were being used from 2015 on up to, 2022 when this commercial came out. Why were the use of these email addresses not pointed out anytime prior to this? I understand that email addresses are part of the domain. I understand that argument from a technological standpoint, but why wasn't this noticed before?
I can't say why it wasn't noticed by my client before, but there wasn't a final judgment in the prior case until mid-2020. And I don't know that his time for, seeking relief on that would have run until then. I'm not entirely sure on that. But regardless, there's no way that you can kill a domain while still claiming to have the right to use it for your email server. Just as I could not set myself up an email address, nathan@kscourts.gov, because it's not my domain. If you are compelled to give up and kill or shelve a domain, that would require you to not use it. And by hosting their emails through the domain, they're clearly using it. And having required that my client pay to maintain the registration of that domain, it would be even more inequitable at this point to now allow them to host their own email through a domain paid for by their competitor. So what we have here regarding the settlement contract, as well as the court's order from which the appeal is pending, is what I would term selective noncompliance. What you'll notice in the appellant's brief is they're not asking you to set aside the settlement agreement. They're simply asking you to ignore this term of the settlement agreement with which they no longer agree. If the settlement were actually illegal or unenforceable, then the entire thing needs to be rescinded, and that'll open a Pandora's box, because the settlement agreement was lengthy and resolved numerous tort claims between both parties, the division of the assets of the prior law firm, the handling of the debts of the prior law firm, the shelving of pistotnik.com, which is a separate domain which my client agreed not to use. A whole host of issues were all tied together in the settlement agreement, and a party doesn't get to just say it's illegal, so I'm not going to abide by one term with which I no longer agree. And the same thing is happening with the court's judgment. The appellants have elected to enforce the provision requiring my client to pay to host the domain, but they don't want to comply with the portion of the judgment prohibiting them from using that domain.
Counsel, you have about 1 minute left.
I cede the rest of my time unless there are any questions. Thank you.
Thank you. Appellant, you have 5-minute rebuttal.
Oh, we can't hear you, sir.
I think you're muted. Cannot hear you.
Okay. For some
That's
reason,
better.
my
Thank
audio
you.
got cut off. I'm sorry about that. First thing I'd like to do is address the acquiescence argument. In the Alliance mortgage case that was cited in appellee's brief, that case referred to an exception to that rule, and it's called the protective measure. And that protective measure exception was created in a case called Plein, P-L-E-I-N. But in this case, we filed our notice of appeal on August 7, 2023. We wanted them to pay for the website and follow the court's order. We tried to follow the court's order. I had no intention of disregarding any of the court's orders during the pendency of the appeal. We agreed to shelve the Pistotnik Law website during the pendency of the appeal. And then after the receipt on August 16th, we filed a docketing statement. There was nothing in any of our actions indicating we were not going to continue with our appeal. We were just trying to comply with the court's order. With our equitable estoppel argument, basically in this case, appellee is basically saying the domain is not only pistotniklaw.com, but also the email addresses. And that actually helps our argument. Our argument is we've used the domain from 2012 we've used the domain forever. But in particular, we've used the domain from 2015 to 2022, and Brad hasn't done anything to try to stop that during that 8-year time frame. So they basically should be stopped to try to do something at this juncture.
But isn't that a problem of your own making? Didn't you agree in 2015 not to use the domain?
That was a condition upon the receivership closing. From our perspective, it was a condition precedent for all the terms of the contract. You know, let's close the receivership, and then we agreed to do all this. And none of that ever happened. That's all I have. Thank you.
Okay, thank you, counsel. We appreciate the arguments, and we'll take your case under advisement and get you a written decision.